welcome to Rightly Decided, the mostly originalist takes of the litigators of the Texas Public Policy Foundation. I am here with attorneys Nathan Seltzer, and Clayton Calvin is finally back with us.
Yes.
Returned from the motherland.
Afar. Yes, that's true. We should do a whole podcast about it, but not now.
Yes.
Another
Okay. Well, Nathan.
That's not what this podcast is about.
Nathan and I are excited to have Clayton back with us
Yes.
today.
Thank you. It's beautiful to be back.
Mr. Weldon is out today. He is helping our law clerks adjust to their new summer clerkship. So it's an exciting day for most of the country. I think this is like the first week of summer.
Summer day one, yeah.
And so because it's the first week of summer, we have a very exciting cruise ship case that we're going to talk about today.
Yeah, good point.
And also an Eighth Amendment dig, which is a lot less
Maybe that'd be better
summery.
for Halloween or
something
later.
A death penalty case is a little bit less summery and exciting. But all the same, let's get into it. Let's start with Havana Docks. This case was released last week. Havana Docks Corporation versus Royal Caribbean Cruises. Nathan, will you tell us the story? What's the story here? Because it's weird.
It's kind of cool. There's a lot of facets to this. The opinion's fascinating. The case setup is fascinating. And it goes back to like 1905. So in 1905, Cuba was not communist, if everyone remembers. And it was actually, there was a lot of traffic back and forth between Florida and Cuba. And it was a hop-in place. Havana was like the place to be. And so some companies, and what wound up being an American company, decided to contract with the government of Cuba and to build docks at Havana. And so the company that wound up with this concession from the Cuban government was Havana Docks. They built the docks with the understanding that they would be able to use them for like the duration of a 99-year lease.
So just slow you down. By concession, you mean like,
Yeah.
You always do.
Yeah.
By concession, you mean like lease, sort of the ability to use a chunk of land, right?
So the Cuban government didn't have the resources necessarily to build all the docks and everything like that. So what they agreed was that Havana Docks would build the docks and then be able to use them as sort of the payment for building the docks that would be owned by the Cuban government.
So
for being allowed to have built the docks in their country.
Right. So Havana Docks didn't actually own these docks in a true ownership sense.
Right. They just had a 99-year lease, which, by the way, when we talk about property interest in the United States, a lot of times that's considered to be almost like ownership. But they had this 99-year lease, which would expire in 2004. And it was to pay them for having built this infrastructure in Cuba that the Cuban government would then have owned for the rest of time. Mm-hmm. And so they built the docks and they were using them for a number of years without trouble.
Until
and then in 1959 there was a small event that happened.
A little geopolitical event.
Yeah, which was the Communist Revolution in Cuba. And one of the things that was expropriated by Fidel Castro at that time was the Havana Docks. So the interest that Havana Docks Company had in these docks.
So they seized it and they nationalized everything. Well, probably it was like all private property, not just American property.
That is correct. However, Fidel Castro specifically called out the Havana Docks and was these are docks that we are seizing and we are nationalizing these docks.
Yeah.
So the docks themselves were stolen and nationalized. Stolen is probably the wrong word. They were expropriated.
It was a government taking. Yeah. And so the Havana Docks Company was not able to make use of the docks anymore, which they still had at the time 44 years remaining on their lease. So we can now fast forward to 1996. At this time, Havana Docks still has a lease that they can't use on their property, on the docks in Cuba. And in 1996, there was an incident over international waters in which Brothers to the Rescue, an organization that had been dropping anti-communist propaganda like leaflets over Cuba, they would dump like potentially millions of leaflets over Cuba that was basically saying you can be free and this kind of thing.
Encouraging the citizens to rise up against communism.
Yeah, because they probably didn't have access to information from outside the country.
Right. It was almost like a Radio Free America type thing. Mm-hmm. And they were distributing this anti-communist leaflets. And by the way, these were like Cuban immigrants to the United States who were then going back to their brothers in Cuba and giving them information about why freedom is better. And we could, and so it was what they were doing was good, but Cuba was very upset. And the Cuban government numerous times notified the State Department in the early 90s, these guys are doing this thing. We're going to shoot down these aircraft if they keep doing it. And these are like unarmed, slow Cessna aircraft. Okay, so these are not.
So they're just coming over from Florida or whatever.
Yeah, it's not like a supersonic aircraft.
Right.
Like,
this is not like an F-22 or something that's flying way high above, super fast. It's like, no,
small plane.
We could probably shoot you out of the sky with a bow and arrow, my guy.
Yeah. So the Cuban government warns the State Department. The State Department actually warns Brothers to the rescue. They're going to shoot you down if you keep doing this. And they, to their credit, they said, we're willing to risk it because we need to get this information to the Cuban people. Mm-hmm. Yeah. So they do it. And in February of 1996, they are flying toward Cuba. They haven't gotten out of international waters yet. It's pretty much undisputed. And Cuba scrambles a Russian-provided MiG-29 in another plane. But this Russian MiG is like the state-of-the-art aircraft. It'd be like scrambling a joint strike fighter to shoot down like a hot air balloon.
Yes, all of those things mean something to me.
Sorry, I get
the
a little
gist.
nerdy on
Like, yeah,
I
agree.
This is like a very sophisticated, state-of-the-art fighter aircraft against a single prop plane flying very slowly from the United States to Cuba. Okay, and they shoot down both of these planes. Oof. I was trying to determine in the incident if we know if they use missiles or guns, like too close for missiles, switching to guns type thing. And I don't know the answer to that. But they shoot them both down, and they're like very excited. Like we have recordings of the radio chatter from these Cuban pilots that shot down these Cessnas, and they were like very excited that they shot down these propagandists. Like they knew exactly who they were shooting down. They knew they were unarmed.
Yeah.
And they did it anyway. And then they were like
the pamphlets.
Yeah, and this actually turns out to be Cuba's greatest air-to-air military victory in the history of its country.
It's shooting down planes with pamphlets for free.
Does actually relate to this case, sweet listeners. This actually is going
but
somewhere.
This is fun. This is great.
Oh, sorry, did I spend too long on this? Yeah.
No.
Well, we can tell what Nathan's special interests are.
Yeah.
Okay, so after all of this happens, Congress responds by passing the LIBERTAD Act. And this is what, 1997?
96, actually.
96.
So like same year.
Okay, so the same year this
So all
happens.
that happened in the 90s and precipitated the passage of this act.
The LIBERTAD Act.
So what the LIBERTAD Act did, it did a few things, but one of the main things is that it said that if a company had its property taken by the Cuban government, then anyone that trafficked in that property would be liable to the person that had their property taken. So so just to apply it to this case, anyone that used the docks that were taken from Havana Docks Company was considered to be trafficking in stolen property for the purposes of the LIBERTAD Act. And that company would have to pay Havana Docks Corporation based on a formula that had been calculated back in the 60s, or back in 1996, but had been goes back to
kind of
1960.
And applied by like a commission that was set up by the act, right?
Right.
Yeah.
So the statutory, the damages that they calculated was like $9.2 million, and it was calculated based on like 1960 dollars.
Because there's an annual like interest accruing also, and I think it accrues from the time that the property was confiscated by Cuba.
Right.
So and not even when the
not
cruise
even
lines were
from when the cruise lines were
using it.
And you say cruise lines, what are you talking about?
Yeah.
Right.
Okay. So real quick, just to drill down into this a little bit, there's a couple important terms. So under the LIBERTAD Act, this applies to property that the Cuban government confiscated on or after January 1st, 1959. And in order to receive this money, a plaintiff would have to show that the defendant trafficked in the property, and that's the important term there, trafficked in the property, such as by knowingly and intentionally using it without authorization. So we're defining trafficking as using without authorization.
Mm-hmm. Right.
And that the plaintiff is a United States national who owns a claim to the property. And we'll drill down into that a little bit in a minute. But also importantly, by its own terms, the LIBERTAD Act could be suspended by the president. And every president suspended it until Donald Trump. But before we get to Donald Trump, let's talk about what happened under Barack Obama.
Yeah, so at the very end of Barack Obama's presidency, so we're now fast forwarding 20 years to 2016.
And this is now 12 years after the Havana Docks property interest had expired.
Yeah, so the lease would have expired for Havana Docks in 2004.
Okay.
Only 8 years after the passage of the act.
Right.
Yes.
And so in 2016, Barack Obama is working to normalize relations between the United States and Cuba. They had a I almost said it like in the Spanish accent, Cuba. Yeah. And he had a joint press conference with Raul Castro, and they was trying to normalize relations. And one of the things is he did, that Barack Obama did, and like at the end of 2015 into 2016, is he lifted the ban on travel to Cuba. And so, and they started granting, the State Department started granting licenses, and then eventually just said you can just do it to go to Cuba on cruises. So Royal Caribbean, Norwegian, MSC, and Carnival started doing cruises to Cuba. There's only one real dock that they could use. It was the Havana Docks.
So they're effectively doing this under the protection of the president at the time, who said, I'm going to withhold enforcing this act.
Right. I'm not enforcing Title III. And also, he's kind of inviting them, like, come and do this, guys. Yeah.
Which was that's his whole policy.
Yeah.
Right.
Yeah.
Because we're normalizing relations.
And specifically, they actually gave, like, the petitioners in this case went to the State Department and asked, can we do this? And they said, yes, there's like a lawful travel exception to this law, and you're allowed to do it. Well, they should have contacted Havana Docks because they said you're allowed to do it subject to any regulations or laws that apply. So what they should have done is looked at this law and said, maybe we should make an agreement with Havana Docks, whatever. They didn't do it. So they start doing these cruises for about 3 years. And then the Trump administration comes in and restores the prior order where it said no longer can you go to Cuba, the cruises go to Cuba anymore. And I'm going to undo the suspension of this private right of action going all the way back and say that now anyone can bring this private right of action under the LIBERTAD Act. And so Havana Docks.
Yeah. So cruise lines, if you go from now forward, you can be sued by anyone who owned any of the property.
But they couldn't go anymore. But they couldn't go anymore.
Yeah.
So this is kind of retroactive.
Right. It ends up being retroactive. Yeah. But also the statute itself is retroactive. It's you know, people who are trafficking in this can be sued.
Passed in 96, applying to property from 54.
The point of the LIBERTAD Act is not to necessarily compensate Havana Docks or any other company. It's to punish those who are enabling the communist regime to continue doing things like shooting down aircraft by funding them and giving them the things they need.
Or bringing like cruise line, like people in a cruise ship to that country.
Sure.
Right.
We want to punish people for doing that.
And this is like disincentivize relationship with Cuba.
Yeah.
So let's now that we have all of that under our belt, let's zero in on the issue in this particular case. So what actually comes up to SCOTUS is the question of, does it matter that Havana Docks' interest in the property expired in 2004 before the cruise lines started trafficking, started using these docks? In other words, when the statute says trafficking in property, does the statute mean trafficking in the docks, or in Havana Docks' interest in the property? Because if it means the docks, it doesn't matter when their property interest expired. It was their property interest when it was confiscated. It was their property, and then it was trafficked at a later date. But if it means the interest in the property, then no, the things that happened after that interest expired do not subject people to liability.
Cruise lines are no longer trafficking in that
under the
property.
LIBERTAD Act, right? So where do we end up? What does the majority say, Clayton?
Well, the majority is 8. It's an 8-1 opinion. So pretty much everyone except Justice Kagan says that they reverse, I believe, from what the 11th Circuit said.
Right.
And they say, the majority of the Supreme Court says that property means property. It means the object. It means the thing. It does not mean the property interest. And Kagan just says the opposite. I feel like it's a pretty clean cut between what the majority says and what the dissent says. So basically they're saying like anyone, what the act says, what it means, what the plain text of the act says is that anybody who uses any of this confiscated property, like ever again, basically, can be sued. Which makes sense if you think about this act as a diplomatic relations act rather than a way of like restoring people's property interest.
Yeah.
But go ahead.
Before we go too far into this, the judgment of the court that we're arguing about here is a judgment of over about $440 million from these cruise lines to Havana Docks.
Yeah.
And that's calculated based on, there's a triple damages provision in the statute and the statutory interest that Clayton mentioned earlier. And when you calculate all that up, it comes to $110 million, which they then assessed against each of the 4 cruise lines involved in the case.
It's kind of funny, and almost like the penalty gets worse and worse, like as time goes on, even though this is based on a like relationship between the United States and Cuba that existed at a certain time in history. It's like you get more and more penalized in the future because of the interest.
But these are all things that Congress really, it's in their purview to decide, like the sort of international relations
The court's
concerns.
just deciding what does the act say. That's all. Yeah.
Right. So the court's not saying this is a good idea or bad idea.
Right.
And what the court decided the act said here was, no, when Congress said property, they were intentionally tainting that property. Like this property is now tainted, and anybody who traffics in this property is going to be penalized. You're going to get these treble damages. You're going to get all of this interest accrued from the 60s. We really, really want to keep people from doing this.
Away from Cuba. Don't even touch it.
Leave Cuba alone.
And importantly, they're saying that, what you just described, instead of we want to compensate the people, our nationals who had their property confiscated.
Right.
So we're not trying to because then property interest would be a more like a fitting reading of the term property. But that's not what the statute was doing. It was we want to taint all of it.
Right. And there, I think, is kind of a knee-jerk sort of equitable reaction that we get in the concurrence from Sotomayor and Kavanaugh. Fun fact, that is SCOTUS GAMI, I learned. It is the first time the two of them have joined an opinion together. And I'm so proud of them for working together to point out kind of this weird equitable problem that emerges here. Because under the language of the statute itself, it seems like any passenger on the boat who used the dock, who set foot on the dock without authorization from Havana Docks, any cook on the boat that transported somebody there,
anyone going to Margaritaville,
trafficking, anybody going to Margaritaville. So you and theoretically every single one of those people is liable under a plain reading of the statute that $110 million.
Yes. So
accrued from
the crazy thing is that everyone would be liable for exactly the $110 million. Like it's not like, so like if you were potentially also, each cruise line went there multiple times, and each instance of the cruise docking at the dock could be considered an individual trafficking incident and could subject them to $110 million. So there's a potential, and Justice Sotomayor raises this in her concurrence, there is a potential unlimited recovery problem. The Supreme Court did not decide that part of it. That's going back to the lower court.
Because that wasn't decided by the 11th Circuit. There were a couple other issues that the 11th Circuit didn't touch.
Right.
And Justice Sotomayor and Justice Kavanaugh wanted to flag this particular issue for them and
make sure, however it is that you end up reading this statute, when it comes before you again, just bear this in mind that, you don't want to read it in such a way that, because double recovery and all this stuff, like there are some due process considerations in there. And so
that's the great thing about concurrences, and why we love concurrences and dissents on this podcast, is that justices can say things in a concurrence or a dissent that they could not say if they're writing the majority opinion, because this is sort of
be an advisory opinion another way.
Otherwise, and so, but they can sort of raise the flag on this, like, hey, if you were to decide this way, that would be really dumb, because then we could just infinitely sue these companies forever.
Right.
Like that can't be right. So make sure that you think about that.
But if you do that in a concurrence or a dissent, there is still a case or controversy. You're not exceeding your authority to do that.
Right.
Whereas the majority was limited to that one single discrete issue that was brought up by the 11th Circuit, that was passed on by the 11th Circuit, which was, is it the property interest or is it the property? And just to drill down on that particular issue again for another second, I want to read an analogy. It's Justice Thomas that writes the majority here. An analogy that Justice Thomas makes. He says, if, for example, your car is stolen and the thief lets another drive it, the other uses your car, but he does not use your property interest in your car. So requiring a one-to-one correspondence between the property interest confiscated and the property interest trafficked would lead to the surprising result that entities could freely use, quote unquote, many kinds of confiscated property without exposure under Title III.
Yeah,
so,
Title III being just being exposed to like,
being the LIBERTAD Act,
I need to somehow compensate you or pay for like that little portion of the item that you used, the car that I used.
For example, if I lease my car, if I lease my car, but somebody steals my car,
You have a
I don't have
possessory
to
interest.
Right, I have
Yeah.
a possessory interest in the car. I don't own the car. I lease the car.
Yeah.
But at the same time, the guy who steals my car has stolen my property.
Yeah, and it's
in our
like
normal parlance,
the
that's what we
wrongdoing.
understand that to be, right?
Yeah, right.
And I couldn't recover if I had to show that he had stolen only my property interest in the car, only that he had stolen my possessory
Well,
interest in the
you
car.
could recover like if you were operating under a theory of reclaiming your property interest, but in that situation, like the stolen car, that's just an independent tort of like conversion or whatever,
Right.
stealing. It's an independent wrongdoing that you stole that object. They're just different claims.
Yeah,
Right.
in this case, Congress has passed a law, and they really want to punish wrongdoers, right? And
Right.
so-
This is a
yeah.
deterrent statute. This is here to make it hurt to do this behavior.
If not for the law, then I think that Justice Kagan's dissent would have a way more force, because the lease expired in 2004, and this was all happening in 2016. And they would just say, well, there's no tort, there's no wrongdoing that's happened, because at least not to Havana Docks, because they don't have an interest in the property anymore.
Right.
But the law says that this taint goes back, and until the taint, and that's the word that
That's the
Justice
word
Thomas
Justice Thomas
uses.
uses.
It's a legal term of
That's
art.
8
It
justices
is
on the
a
Supreme
term
Court.
of art.
Yeah. So until that taint is cured, then anyone that uses it, doesn't matter how far in the future, will be liable to, in this case, the Havana Docks Corporation. And so the only way that the taint could be cured is if Cuba either restores the property rights or compensates Havana Docks. And that's what the statute says, and Justice Sotomayor goes into that in her concurrence.
So it's putting pressure on Cuba by putting pressure on our own nationals, because that's who we have jurisdiction over.
Right.
And there's kind of a weird wrinkle to this whole statutory structure, which is that this is essentially a citizen supervision, like you just said. It's restoring to the American people who were harmed treble damages for wrongs done functionally by other Americans who were colluding with the Cubans. It's a weird citizen, like a
Yeah.
proto-citizen suit
Yeah.
statute.
Right.
That leads to all kinds of weird due process problems. And anyway, I'm really curious if this is going to come up again in some other ways, if we get to keep talking about cruise ships in Havana.
Yeah. Yeah. I wonder how there were a lot of issues, due process-y kind of issues that I feel like Sotomayor did talk about and could have talked about. But also like in this posture too, it's kind of like good luck. Like this is like a Congress's plenary powers over foreign commerce
yeah.
and like international relationships and stuff. Like it's kind of hard to, I would imagine, not that I've ever brought such a suit, but to, bring up some due process theory.
It would be really hard to defend on due process grounds. Yeah.
And think about this. The government actually told the cruise lines, you're good to go.
Oh, yeah.
So,
There's a huge equitable issue there.
Yeah. So if it was the government that was doing the suit, they would almost certainly not be able to bring a lawsuit here. But because Havana Docks is a private actor, they're not precluded from doing that, because the government doesn't bind Havana Docks. They just bind themselves.
So is there a retroactivity issue here? Because the cruise lines did this during Obama's presidency. Or
No,
am I
it was
wrong?
during Trump's presidency, but it was
okay.
while it was legal. They
Okay.
only did it while it was
While the travel itself
Yeah.
was legal. Yeah.
Well, the travel was legal, but the suspension of the enforcement of this act had been stopped.
No, the suspension wasn't done until 2019 also.
So this is just all retroactive.
It's everything's retroactive. Yep. It was done in 2019. So 2016, 2019 is
very
like pretty
much.
much mostly Trump's presidency.
But
But he
do
didn't
have
undo
a Calder
anything.
versus Bull problem that says this
Bringing
is
it
not
back.
a criminal action.
Everything
This is
ties
a
back to
civil
Calder
action.
versus Bull.
Everything,
So much
always.
does.
It all comes back to Bull. Okay, let's shift gears for a minute and talk about the death penalty. Let's talk about Hamm v. Smith. So this is a unique case posture that we don't normally see. Those in the know.
I forgot. We have to do the score.
Oh, I'm so sorry, Nathan. Give us the score on Havana Docks.
Okay, so
yeah.
Havana Docks 8-1. The Supreme Court decides that Havana Docks can recover. We don't know how much yet, but they can recover up to $440 million from these 4 cruise lines for the use of their property dating back to a claim in 1960.
But there is a whole bunch of questions that the 11th Circuit still has to answer before we get there.
They
So
should have
many
known.
questions.
They should have known not to go to Cuba, to Margaritaville.
Don't go to
It was
Margaritaville.
beckoning, but they shouldn't have taken it up.
The margaritas were beckoning.
Okay, turning the page.
Anyway, turn the page. Hamm versus Smith was digged. What is a dig, Clayton?
Dig. It means dismiss as improvidently granted. So basically, it's the Supreme Court saying, yeah, we granted this case, but we
granted
don't want
this
it
cert,
anymore.
and we wish we didn't.
Yeah, we took a second look, and we want you to get it out of our face.
We've got some buyer's remorse now.
Yeah. So it's kind of funny because in order for the Supreme Court to grant certiorari, which is the term used for just when they decide to take a case, which they don't have to in most situations.
We'll start with certiorari and then go forward to a dig. So
yeah, right. So certiorari means that this is the term used when the Supreme Court takes up a case. It only requires 4 justices in order to take a case. So you don't need a majority of the court to decide to take it. And then obviously you need a majority to determine the outcome. But so they took this case, 4 justices said yes, and then 5 justices said no. Yeah. So presumably the other 5 justices were
we shouldn't have done this.
Yeah. So it's kind of a funny thing that it takes 4 to grant, but 5 can actually dismiss it again. It doesn't happen that often.
I think it's probably almost a rule of orderliness kind of thing where the justices typically say, all right, if 4 of you want to do this, we're going to decide it on the merits.
This far.
We're not going to turn around and say, no, we're actually not going to hear it.
Unless we really think that we should.
This one is also kind of odd. According to SCOTUS blog, this is the most relists that a case ever had. So when they were deciding whether or not to grant cert, they debated it something like 23 times before they decided to grant cert, which makes it even funnier. That's probably unkind of me, but still, it makes it understandable maybe that ultimately they were like, we're going to dismiss this as improvidently granted.
So a relist is when they discuss the case at conference.
Yeah.
And then they
discuss granting cert at conference.
Yes, so they're discussing whether or not they're going to grant cert and review the case at conference. And then they say, we need to discuss this some more or discuss it later instead. And they put it off, and they did it 23 times. It came up in a conference, and they said, let's talk about this later.
If I discussed anything 23 separate times, I would be super over it.
Yeah, you
maybe that's
think,
what happened.
Maybe. So I do have a guess, and we'll get to the guess as to why they digged it. But let's talk about the case itself first. So this is Hamm v. Smith. Mr. Smith was convicted of murder and sentenced to death in the state of Alabama. He has a very low IQ. It's not clear exactly how low, and that's part of the issue in this case. But under Atkins v. Virginia, you cannot, the Supreme Court held that it violates the 8th Amendment to execute an individual who is intellectually disabled. The problem with Atkins v. Virginia is that the court left it to the states to develop appropriate ways to enforce that limitation that they created. So they said the rule is you can't execute intellectually disabled people.
Yeah.
You all go figure out now how you decide whether or not someone is intellectually disabled. The Supreme Court of Alabama later on wrote their own rule for this, and this is just kind of the standing rule in Alabama.
This is from a previous case also.
This is from a previous case. This is from Ex parte Perkins, which was a 2002 case. The Supreme Court of Alabama said that their test is going to be that the defendant has significantly sub-average intellectual functioning, which they read to be an IQ of 70 or below, significant or substantial deficits in adaptive behavior. I can tell you that no one really knows what that means. And manifestation of these problems during the developmental period, i.e. before the defendant reached the age of 18. So basically, what it boils down to in Alabama much of the time is what IQ tests did we have from this person in their childhood, and was it under 70 in their childhood?
Like if your IQ tanks after you hit 18.
Right. If you suffer a TBI when you're, 21.
Traumatic brain injury.
Yeah, traumatic brain injury, and now your IQ is like 59, that may or may not get you there. It is a very unique test. And the question that makes it to the Supreme Court is that Mr. Smith has been repeatedly IQ tested, and his IQ has ranged from, I think, 65 to 72. I don't have it in my notes.
He's right over that threshold.
He's right around that threshold of an IQ of 70. And so the question is, are we supposed to average these scores? Are we supposed to take the lowest score? Are we supposed to take the highest score? But if the confidence interval is actually below 70, then that highest score puts you below 70 anyway. Like, which score are we supposed to use if we've got all these competing IQ scores?
And also, I mean, that's still only one part of the Alabama test is the IQ scores.
Right.
There's still other things to factor.
But it is the prominent one. It's the one that's
this case turns on it.
This case turns on it. And So that, and also kind of undergirding all of this is the question of, is this actually the right test?
Yeah.
That I don't think is a question that was preserved or granted cert, but it's an underlying question in all of this. Like, how do we really know if someone is intellectually disabled? So this gets up and down and up and down and up and down within Alabama, and then to the federal district court. The federal judge grants a stay, saying no, he's demonstrated that he's intellectually disabled. The 11th Circuit maintains the stay when it gets up to the Supreme Court. So this dig then is the court saying, actually, even though we granted cert on this, we're not going to review it, and the 11th Circuit's stay of his execution is going to remain in place. Mm-hmm. So what kind of things would we expect to see to lead to a dig under these circumstances? What do you guys think?
Well, I think when they granted certiorari, there was obviously some kind of split, something that happened. It's possible that we can't really know what the justices were thinking, but I think one thing is possible is that they were looking at the facts of this case and whether or not this is going to be a good case to make law on.
Mm-hmm.
And
how are we going to influence the Atkins decision and inform what intellectually disabled means?
Right.
And inform states about what tests might be okay and what tests are not.
So when you get into the case, I think that it's perhaps that it was a pretty heinous murder. I'm not going to get into the details of it because this is a family-friendly podcast, but it wasn't.
There was an electric saw involved.
It wasn't. It wasn't a heat of passion sort of thing, or something that
a robbery for $100.
Yeah, it was a robbery for a very small amount of money.
And so it's possible that while the test that Alabama employs may not have been favored by the court, that they don't necessarily want to stop the execution of this guy under those facts. Also,
so there might be a little bit of bad man stays in jail playing around in the background here.
Well, except that
they're not saying that they're not going to bless the stay. In other words,
right.
By dismissing as improvidently granted, they're not blessing the stay, but they're also not overturning it because the stakes here are pretty high.
Mm-hmm. Yeah, I mean, the stay is going to be in place, and I mean, he's not going to be executed.
Right.
Yeah. Right. So he won't be executed now. It's possible the Supreme Court just didn't want to make a decision saying we're not going to execute this guy because of how heinous the actual murder was.
Yeah.
But we don't really know.
That would be like a factual consideration that might be in the background, but there's also legal issues that they didn't want. Because if the issue is just, what does Atkins mean, and is 70 IQ like the correct threshold? Do they want to bless Alabama's test? And if it's just about IQ scores, this is still a really legally murky case because the IQ score was only one of the factors in Alabama's test, and even then applying that with the averages. I mean, do we only take into account the averages, when they are, I don't know, like close to it's close if they overlap the threshold or if they're above or below. So there are a bunch of reasons that they might think we might distort the law a lot. I think around this and be unclear.
Yeah, we have a vehicle problem here. I think it bears mentioning, though, that in spite of the vehicle problem, there's 63 pages of opinion in this. We have
for a one-sentence order.
Right, for a one-sentence order, we get 63 pages of opinion. And let's see, it's Justice Sotomayor and Jackson concur, and then Justices Thomas, Alito, Gorsuch, and the Chief Justice Roberts, dissent. So we've got the four justices that dissent would I assume, if nothing else, they want to hear it. They want to make some sort of decision about it. And then
it sounds like it's maybe sort of like the liberals on the court who just want to make sure that they preserve the core holding of Atkins without messing it up too much, so that the protection for intellectually disabled defendants still exists, and they don't want to distort it too much.
Right. And then there's a note from Justice Sotomayor in her opinion. The court's review is further complicated, in addition to the things that we've sort of described, by the fact that the issue of how to consider multiple IQ scores was neither meaningfully raised nor passed on below. In the district court, Alabama never argued that the court must, as a matter of law, combine all IQ scores using any particular method or set of methods to assess whether an Atkins claimant has significantly proven sub-average intellectual functioning. So that's a big deal.
Factually murky, legally murky, and procedurally really murky.
Right.
Yeah.
None of these are things that the court is going to be excited or eager to wade into. But
Trifecta.
it's the
Yeah.
it's the trifecta.
That's
That's how
terrible.
you get digged. That's how you get digged.
Doug.
Doug.
Dig
But
Ed.
on
Dig.
the Eighth Amendment itself, I'm curious what y'all's thoughts are in an originalist sense about using the Eighth Amendment to justify, and this might be more of an undeveloped thought rather than like a rather than
Full-throated
a
thesis.
full-throated
of
thesis.
What we all think.
But using the Eighth Amendment to justify the denial of the death penalty for intellectually disabled defendants. I'm curious what y'all's thoughts are about how we as originalists approach the Eighth Amendment in this context.
Yeah.
I think we want to go back to the founding and look at when we because the Eighth Amendment says, we should talk about that in this case we're talking about cruel and unusual punishments, and that's prohibited by the Eighth Amendment. And so would it have been considered a cruel and unusual punishment around the time of the founding or around the time of the ratification of the 14th Amendment, because that incorporated the Bill of Rights against the states? Would it have been cruel and unusual punishment to execute someone who's intellectually disabled? What that means now and what that means then might be different, but was there at least a concern, or was that something that was looked at? I don't know the answer to that.
I
And
don't either. And
I think the way
I
that
think
you've
that's
just
the key.
framed that is so important. I think when people think about originalism, they assume that the question that originalists are going to ask is, did the founders execute disabled people? And the answer to that was probably yes. Just like on balance of probabilities, sure.
Yeah, if they saw a murder as gruesome as this and the guy who did it was also dumb, they wouldn't have been like,
That's not a mitigating-
let's stop.
Yeah.
Right. But
He's a threat.
that's not really the question. The question is, what do they consider cruelty? And based on our understanding now of what
Right.
intellectual disability is and what it means and what
Yeah.
competence is and what it means, and the way science has evolved and the way technology has evolved and our ability to understand the human mind has evolved and changed, would that fit within the original meaning of the term cruelty? So I think when people imagine what originalist jurisprudence around the Eighth Amendment is going to look like, I think they ask the wrong question.
Yeah, right. It'd be an originalist could still ask the question: did the ratifiers, if they knew what we know now, how would this provision apply? It could still apply the same way that we might apply it by modern sensibilities, but you're still effectively asking the same legal question: was this cruelty? But the facts have been updated.
But this is different from like the question of like search and seizure on a smartphone, and like the founders did, like, is a smartphone like a filing cabinet, or is a smartphone like something in your pocket? This is different from that, because while the definition, they didn't have IQ tests at the founding, they didn't use the term intellectually disabled at the founding. But they definitely understood that some people have significantly below average intelligence and that those people are limited in their function. Like, they understood that thing.
Right.
And so when they were looking at those people and they've committed a heinous crime, was it cruel to execute them?
Right.
And so like this isn't like a hard case. Like, hard cases exist for originalism. This isn't really one of those,
Right.
in my view.
Yeah.
Yeah. I don't have enough historical background to be able to answer that question, but I just wanted to point out that the framing of it is important, and the way that we ask the question is important. Okay, so finally, I have one.
Wait, the score.
Oh my gosh, Nathan. You just have to jump in.
I'm
Just
jumping
tell
in.
us the
All right, so
score.
score 5-4. The Supreme Court dismisses the case without deciding it, and the result of that is so it's
Oh, you say 5-4. We don't know that for sure, but we do know that there are 4 people dissenting from it.
Yeah.
So we can
are
assume.
deducing.
We are
Yes.
deducing from the evidence.
But that's the only possible. I'm going to say it's 5-4. If you can
That's
come
the
up
only
with
way
a
the
different
math
configuration of 4 dissenting justices, then that would be fine. But I'm going to say, so with 4 dissents, the Supreme Court dismisses the case without deciding it, and that leaves in place the 11th Circuit opinion, which prevents this man from being executed for the murder he committed.
There you go.
Also, I just did some preliminary research, some real-time research.
Oh, no.
And it was actually more ambiguous, it looks to be, back at the founding, whether this would have been, such an execution would have been permitted, because they
Considered
did
cruel.
actually they did actually prevent people who were mad or insane from being executed sometimes.
Oh, that's fair. Okay.
Lord Cook, one of our favorite
Oh, yeah.
originalists.
Whose name is spelled Coke, by the way. If you want to be cool, you call him Cook. But if you're just reading it because that's how you learn everything,
a great sort
Coke.
of like Enlightenment legal scholar of the 18th century. But he points that out. So maybe there's some gray area.
There's some gray area there.
And we don't know, and that's okay. And the court didn't decide here.
Right.
So,
Right.
Although Thomas's, I think it was dissent, does talk about he thinks Atkins was wrongly decided as an originalist matter.
Yeah.
But anyway.
Okay, so let's talk briefly, very, very briefly, because we only have a few minutes left, about an order that dropped yesterday, Florida versus California. So this one I think is just weird and interesting from a structural standpoint. The state of Florida and the state of Texas want to sue the state of California for giving driver's license to people who don't speak English. Setting aside the merits of the issue, they come to the Supreme Court and say, we would like to file suit over this. And the Supreme Court says, well, we're not going to hear it. So bye.
Yeah.
And Justice Thomas dissents and says, no, we have jurisdiction. Why do we have jurisdiction over this? Why does the Supreme Court have jurisdiction over this?
Well, because the Constitution in express terms gives the Supreme Court original jurisdiction over suits between states. And in Thomas's view, original jurisdiction is not discretionary.
And what is original jurisdiction?
It means you can come to us in the first instance.
You don't have to file in a district court. In fact, you can't.
You have to go directly to the Supreme Court, and the Supreme Court, it says it has original jurisdiction. So the verb is has. It is affirmative. It is positive.
Shall.
I think it's shall. Shall have. Yeah.
Shall
the judicial
have.
power shall.
And So if the Constitution says you have jurisdiction, then you have it. You can't say that you don't. But I don't know. I mean, did they say that they don't, or that
they didn't say anything? They just said,
they just don't want to hear it.
We don't want to hear your case. Please leave. Now, there is some underlying case law that I don't think we really have time to get into, dealing with this kind of discretionary choice not to use jurisdiction that we otherwise have. And Justice Thomas takes great issue with that. He actually points to a Justice Marshall opinion from 1821, Cohen v. Virginia. We have no more right to decline the exercise of jurisdiction which is given than to usurp that which is not given. In other words, insofar as we cannot use jurisdiction we don't have, we can't refuse to use jurisdiction that we do.
And I think he goes on to say one or the other is treason to the Constitution.
Right.
Yeah.
So
yeah,
like he's pretty serious.
He's pretty serious about it.
Just being devil's advocate for a moment. I mean, like legislative power can, for the other branches, legislative power can exist over a certain matter, and the legislature can refuse to exercise it. So should it be the same for a court?
Does the same apply to executive power, though? Can a president say, actually, I don't feel like enforcing this law?
Yeah. Because the text of the Constitution says the president shall execute.
Right. And I think it's basically the same when you vested judicial power. It's the same as vesting that executive power.
Okay, well,
you don't have a choice.
Pretty quickly. Yeah.
So anyway, I have strong feelings about this. I agree with Justice Thomas that jurisdiction which is given you can't just discretionarily refuse.
Yeah.
So Clayton, I got to ask you this: what, was this an advisory opinion?
Yeah. Well, yes, right, because
was the court's refusal to use its jurisdiction an advisory opinion?
Yeah, was it
because it's saying if it doesn't have it's almost suggesting that if it doesn't have jurisdiction, it's still sort of like opining on the matter anyway, which would be an advisory opinion. There's no case yet. There's no case yet,
and they're saying you can't bring one.
Right.
So there's no case or controversy right now.
It's like we're exercising jurisdiction that we're saying that we don't have, in order to tell you that we don't want to exercise jurisdiction that we do have.
Perfect. That's exactly, that's so easy.
Crystal clear.
Doesn't make any sense.
Crystal clear. Makes absolutely no sense.
And that's why Justice Thomas's dissent here is beautiful, because he points out that dichotomy. It doesn't make any sense for them to say no here.
Yeah. Right.
I think I recall at least a few years ago, I don't remember exactly how long ago now, there was a similar issue between Texas and Pennsylvania, and Justice Thomas said, look, we should be taking this. I think it was an election case. We should be taking this, maybe there's not standing. Maybe they lose on, actually, ironically, on subject matter jurisdiction grounds. Maybe
Different
we
type
don't
of
have
subject
jurisdiction,
matter
but we do have jurisdiction
Yeah.
to take this case and
Yeah.
actually hear it. Once we hear it, we can decide whether or not we have subject matter jurisdiction. We
Over
can
the
make that
people, yeah.
decision then, right, over the states involved in the issues and the controversies and what have you. But as a preliminary matter, we are the place where states have to litigate these issues. And if not us, who? There's
Right.
nobody else that can hear this.
Right.
We are given exclusive and original jurisdiction over
Yeah,
these
one of the
issues.
premises of like entering into a union with each other as states is that there would be a forum to like adjudicate our disputes.
Yeah. There's a big fundamental
Like,
problem
undermines the premise of it. One of the
there. The
premises
entire
of the
Constitution.
union.
Yeah.
That's a dramatic way to
Well,
spin it, maybe.
thank you for
the
all that
score.
drama. Would you like to give us the score,
Yes,
Nathan?
Yes, I'm so excited to give the score. So 7-2. We presume 7-2. There are 2 dissents, but the Supreme Court will not allow a suit to be filed between Florida and Texas suing like California and Washington. So they say that suit cannot go forward, but it's not an official decision of the court. There are 2 dissents saying we must take this kind of case, but obviously that's
It's
dissent.
the minority opinion
Yeah.
right now. And the stakes are, in fact, quite high because our entire constitutional order hinges on those things.
Right.
So, all right. I think that brings us to the end of today's docket. Thank you all for joining us. If you enjoyed our conversation today, please leave us a review and join us next time for more Rightly Decided.